Hello, this is Lori Kornblum. I'm an instructor at MATC Paralegal program, and today we are going to learn how to read a case. When you are researching the law, you may find a case in many forms. One way to find it is if you look on Westlaw. You may also get it in printed form. This is a printout that is from the Northwest Reporter. It's a printout from Westlaw. However you get it, the elements of the case are the same or very similar. You can see I've already started annotating the case. But the first thing you're going to look at is the caption. And in the caption, what you have is the case name, State of Wisconsin versus Anna Anina, who's the defendant. You can tell it's a criminal case because it has a CR on it. You have the official site, 2006 Wisconsin App 202, which means that it's in the year 2006, it's the Wisconsin Court of Appeals, and it's case number 202 of that year. You also have, this is a printout from the Northwestern Reporter. It could be found at 723 Northwest Reporter in the second series, and this starts at page 708, and there are also a way to find it in the Wisconsin Reporter. The Wisconsin Reporter would have parallel sites. This is the view showing the parallel sites. You have both the official site, 2006 Wisconsin App 202. You have the Northwest site, 723 Northwest 2nd 708. And you have the Wisconsin site, 296 Wisconsin 2nd 599. These are various ways that you have that you can find this case if you want to look for it in 3 different ways. So as I've said, this is the caption. Below the caption, you'll see which court decided the case, the Court of Appeals of Wisconsin. It tells you how this case was decided on briefs, on the written materials, when it was submitted, and when the opinion was filed. Next, you will find information that is submitted by the editors. In this case, there's the background of the case, and in the background, it tells you the brief summary of the case, and also the editor's view of what the Court of Appeals held. But keep in mind that this is only editorial comments. These are not actually from the court. You then go down the case and you see a lot of information called key sites. And these are various editorial comments telling you how the case is cataloged by the editors. However, again, this is not a part of the official court opinion, and you should never cite to a key site. Finally, you come to a break, and it tells you who the attorneys were who were arguing the case. In this case, it's Robert Hennick on behalf of the defendants, and on behalf of the plaintiff, it's the Jeffrey Sisley, who is an assistant district attorney in Ozaukee County, and the attorney general. Jeff Sisley, by the way, is an instructor in the MATC Paralegal program as well. When you get to the next page, you will see a list of judges, and it says before Snyder, PJ, and Brown and Nettesheim, JJ. Snyder, PJ, is the presiding judge, Snyder, and the JJ just means judges, but they are Court of Appeals judges. So the judges who heard the case are these 3. The judge who wrote the opinion starts here. And you will see that there is a paragraph number. In the Wisconsin court system, you have paragraph numbers for every paragraph. And this is called public domain citation. These paragraphs tell you exactly where you can find the information in the case. Public domain citation has been in existence since the year 2000. So you will see that there is a summary of what happened, and then the background. Usually courts call the background the facts, and when we study facts, we will call them facts, but you might see courts calling them background. And this goes on for several paragraphs. The court will get to the procedural posture later in the background, and then they get to discussion. When you see the discussion, you know that's really where the court starts. So if it says 1 through 5 here, those are references to the headnotes that we saw above. If you look back to the headnotes, 1 through 5, you can see what this is going to talk about. So again, your discussion starts your legal analysis. And in this case, Anina wants to withdraw her Alford plea because she believes that a manifest injustice has occurred. So the court then starts with the legal rule. Withdrawal of a plea following sentencing is not allowed unless it is necessary to correct a manifest injustice. When you are talking about IRAC, this is the rule. And then the court goes further about specifically what is Anina arguing, that the circuit court did not establish a factual basis for her plea. And then there is more law, so this is also part of a rule. And the court is laying out the rule. And then the court summarizes her argument. So basically what she's arguing is that because the search warrant was subsequently invalidated, this is an invalid search warrant. And therefore, if she resisted arrest, it doesn't count. And again, this is what the rule is. The state then is conceding that if the resistance was only to the execution of an invalid search warrant, there is no factual basis for her Alford plea. However, the state shows that Anina's arrest was from her disorderly conduct and was brought about with lawful authority. The court then reviews what the circuit court held, and then it again summarizes the circuit court, and then it gets to what the legal standards are. Again, it is going to look at the totality of the certain circumstances, and it goes through what the circuit court did. And then finally, the court goes through the circuit court's reasoning in great detail. And as you can see, it is discussing this. In paragraph 17 is where the court really starts to begin its reasoning, because it says that the record supports the court's determination that there was a sufficient factual basis for the plea. I label that R. And after reviewing all this information, the court tells you what it concludes. And whenever you see the word conclude, you know that that's an important word, and that means the holding for this case, that the circuit court fulfilled the mandate of the statute when a determination that a factual basis for the plea existed. The court then gives you an observation. This is not actually part of the holding. This is really something that would be called dicta in a case, because it is not actually part of what the court needs to do. Then in the end, the court gives you a conclusion, which if you want to know where the holding is, this is where. We conclude that when the officers were met with disorderly conduct during the execution of the search warrant, they possessed the lawful authority to arrest, notwithstanding the invalid warrant. And therefore, they're not going to reverse the trial court. So that is the holding of the case. So just to review, the court states the issue in the first paragraph, what Anina is contending. The court then goes through the facts of the case, then goes through its reasoning or analysis, and that goes on for a while. And this is all part of its reasoning. Then the court gets to a conclusion, and then finally, in the end, the court makes a conclusion. In this case, the judgment and order was affirmed, and you have that. So that's how to read a case.